Disclosure Requirements When Selling Your Home. Legal, by Louise Aitken. With a busy spring market creeping up on us, let's talk about disclosure when selling your home. Disclosure is becoming more important than ever, particularly with a number of changing environmental factors and the current market conditions. A Section 32 vendor statement, signed by the vendor, is required when selling your home. But what does the Section 32 vendor statement need to disclose? Let's discuss some of the matters that might need to be considered or disclosed when selling. Environmental factors. This can include matters such as flooding. The Land Information Certificate usually provides information about flooding risk. If you are aware of any additional risk or past flooding whilst you have lived in the property, you should advise your conveyancer/property lawyer. Landslide/landslip. This has been a topical matter in recent months, and a number of councils have recently reviewed the local environment, particularly around the landslip risk associated with those properties. If you are aware that your property has been deemed a landslip risk, this must be disclosed. Contaminated land. There are a number of searches that can be done now to ascertain if your land or land nearby has been contaminated or is on the register of contaminated land and currently being managed. Notices and planning. Has your property been the subject of any council notices that may affect the purchaser's decision in purchasing the property? These notices need to be disclosed. If you are unsure if a particular notice needs to be disclosed, please speak to your conveyancer or property lawyer, and they will be able to provide you with more advice in this respect. Planning permits that either affect your property or surrounding properties should also be disclosed. For example, if your next-door neighbour has just sold their property and a planning permit has now been issued to construct a 3-storey apartment block, this should be disclosed, together with any appropriate information relating to the planning permit, so that a potential purchaser is on notice of such planning permit when making their decision. Building and renovation works completed in the last 7 years. If you have completed building works or a renovation within the last 7 years, there are specific requirements regarding disclosure, which often depend on whether the works were completed by a registered builder or by you, which would be deemed owner-builder works. You should provide all information relating to those works to your conveyancer or property lawyer so that guidance can be provided to ensure that the appropriate reports, permits and/or insurances are included in the Section 32 vendor statement as required. Owners Corporation. If you are selling a property which is part of an owners corporation, an up-to-date owners corporation certificate is required from the owners corporation manager, disclosing prescribed information relating to the property. This includes certain maintenance that may be required on the property, any special levies that may be payable now or possibly in the future. You should note that if you are aware of works that may be upcoming at the property, which may incur a special levy, this must be disclosed to a potential purchaser, as it may be payable by them if the special levy is struck after the date of the contract of sale. For this very reason, owners' corporation certificates should always be up to date. If you become aware of any updates during the course of selling your property, you should immediately advise your conveyancer or property lawyer so that they can discuss and provide the appropriate advice to decide what updates, if any, should be completed. What happens when there is non-disclosure? Depending on the non-disclosure, the purchaser may have recourse, which may range from damages to termination of the contract of sale up to the day of settlement. The recourse is highly dependent on what the non-disclosure relates to and if the purchaser is deemed to be in a worse position than they were at the date of the contract of sale due to the non-disclosure. As the onus is on the vendor to provide disclosure, it's prudent to follow the advice of your conveyancer or property lawyer. We understand that it may seem costly to order the additional certificates and provide full disclosure. However, the disclosure is imperative and reduces the risk of non-disclosure. If you're planning to sell your home this spring, make sure your Section 32 contains all relevant disclosures to ensure that the sale process is a smooth one. Louise Aitken is the Conveyancing Manager at Madison Sloan Lawyers in Park Orchards. Contact them via madisonsloanlawyers.com.au.